Now I will talk about each of the three torts of trespass to the person in turn. Firstly, let's talk about the tort of battery. What is battery? You can see on the slide that there is a color-coded explanation or let's say paraphrase of what is battery. You shouldn't take this as a legal definition. It's more my definition or my explanation of battery than anything else. But in the color coding, you will see all of the elements of the tort of battery. You can see that it is an intentional, direct, and immediate infliction of harmful or offensive bodily contact with the plaintiff. We can, through the color coding, break that down into the components of battery and examine them one by one. Firstly, let's consider the requirement that there be contact with the plaintiff. This is essential to having an action in battery. If there is no bodily contact, there can be no battery action. Moreover, the bodily contact must be shown to have been direct and immediate. And this shows a distinction with negligence, because in negligence, where injury occurs, the injury may not have occurred directly and immediately, but nonetheless a negligence action can be brought. Because of historical anomalies, today the tort of battery still requires that the contact be administered directly and immediately. Later we'll discuss how this can lead to some overlap or even some gap in the law. Moreover, it must be shown that the contact with the plaintiff was affirmative and not merely passive. This is all part of the historical requirements which remain with us today. The contact must be direct, immediate, affirmative. We can imagine that, for instance, a plaintiff may be injured because he trips over the extended legs of the defendant, who is simply extending his legs in the aisle. The defendant hasn't moved, but the plaintiff tripped over them. The defendant may even have intended that the plaintiff trip over them, but because the defendant's legs were already extended, this may not qualify as battery. It was not an affirmative movement on the part of the defendant. Now, usually in battery, the contact made is body to body. That's a typical battery case, but it needn't be so. And so, for instance, battery could include cases where the defendant touches the plaintiff's clothing, or for that matter, where the defendant throws an object at the plaintiff, or pours liquid on the plaintiff, or pulls the plaintiff's bag. Those all involve sufficient bodily contact for battery, yet they do not actually involve a body-to-body contact. The requirement of directness and immediacy is key because this will mean that there will be cases that do not qualify for a battery action if the defendant managed to administer the bodily contact in some roundabout way. And it may mean that in such cases, assuming injury is suffered, that the plaintiff would have to bring the action in negligence, or that the action falls into a gap, into no action whatsoever. But later we'll discuss a possibility of a cause of action that might be available in those cases. Now let's look at the element of intention. Here it is necessary to show that the defendant intended or desired bodily contact. Notice it is not necessary to show that the defendant intended injury. Now, there may often be injury. He may intend injury, but it's not required for the proof. Simply that he desired bodily contact. And let's consider the forms of intention. Of course, much of the time, it will be evident from observable facts that the defendant desired that contact. If a defendant pulls out a gun and shoots the bank teller or shoots the policeman, the facts suggest actual intention, and proof of intention will not be a problem. But intention here also includes imputed intention. That is, where contact occurs with the plaintiff, although that's not exactly or actually what the defendant intended. The defendant may have intended contact with someone else in the room, but by throwing in a bomb, everyone is injured. He may not intend to injure or he may not intend bodily contact with the others, but it is certain or substantially certain to occur. So this was also included in intention, and I use the term imputed intent to describe that kind of intention. But it's equally valid as a form of intention as actual intention. It doesn't matter which method is used to prove the intention. And then there's yet another possibility, which some judges have called transferred intention. And an example is in the Livingston case on page 628 of your book. And this happens where the defendant intends bodily contact with person X, but misses his victim, his target, and actually makes bodily contact with person Y. Now, the defendant may deny having committed a battery because he did not intend contact against person Y, but that will be of no help under the doctrine of a transferred intent. The defendant will be liable all the same because his intent will be deemed to have been transferred from X to Y. The plaintiff, having established intention and direct and immediate bodily contact committed by the defendant, must also show that the bodily contact is harmful or offensive. I emphasize harmful or offensive, because often directly administered bodily contact in daily life is not a battery because it's acceptable conduct. So if your friend touches you on the shoulder to get your attention, although there is intention and there's bodily contact that is direct and immediate, it won't be a battery. And that's because in that case the contact is neither harmful nor offensive. Now, harmful contact is easy to understand. Harmful contact is often injurious contact. It results in injury. It results in pain. It's a sort of contact we don't want. But and injury, wounding, that sort of thing will certainly qualify, or any sort of injury, I suppose. But what's more difficult sometimes to identify and understand is where the contact is not harmful, but it is found to be offensive. If it's offensive, then it also qualifies for battery. Offensive is not an easy concept to define or to identify when it happens. Some of the courts, some of the decisions have explained it as being contact that is outside of the accepted usages of daily life. The sort of contact that we don't expect. So that, again, most social contact, most ordinary social contact is not offensive. And this is true, probably, even if the social contact in that particular instance is not wanted. I mean, a stranger may tap you on the shoulder in the MTR station looking for directions. And you may not want to be bothered in such a way, but nonetheless, that would not be a battery because, broadly speaking, that sort of contact is considered acceptable in society. The case of Collins and Wilcock on page 630 of your textbook offers an example of where contact is offensive because it is outside of the accepted usages of daily life. And Collins is an interesting example because you may find the outcome to be somewhat surprising. In that case, a policewoman was seeking to ask a suspect some questions. In fact, the suspect was thought by the policewoman to be a prostitute and engaging in prostitution solicitation. So the policewoman spoke to the suspect and asked some questions. The suspect did not cooperate. So the policewoman grabbed hold of the arm of the suspect to speak to her. There was no harm caused, no injury caused. But the court found this contact to be offensive as being outside of the accepted usages of daily life and therefore would qualify as a battery. Now that may seem surprising because you may think that a police officer doing her duties is entitled to do such a thing. But on a close examination, the police officer was not making an arrest, and she admitted that. She was not making an arrest. She was just trying to find out some answers. She was merely making some inquiries of the suspect to find out what she was doing. That being so, the police officer is committing a battery if she grabs the suspect's shoulder. Just as you and I would be committing a battery if we grabbed a stranger's arm or shoulder in order to ask a question. And the police officer is no different in that sense, unless the police officer is acting under a duty of a power of arrest, which she was not doing. Here we can see the tort of battery operating in its social context, protecting the civil rights of a citizen. A final or another characteristic, which I've already mentioned, a characteristic of battery, as with all of the trespassory torts, is that that battery is actionable per se. And this is so because it is important for the plaintiff to have the right to sue or to prevent people from touching him or her through the power of a cause of action. If damage was required, or if injury was a condition for battery, as it is in negligence, this would mean that people could engage in all sorts of antisocial touching, and there would be no mechanism for the plaintiff to stop that, because no injury or damage is caused. So here we can see how battery protects the dignity of the person. In the case of Collins is actually an example of that. The dignity of the person is protected. A question for you: is it necessary for battery that the plaintiff be aware of the contact? Or can battery take place even where the plaintiff is not aware of the contact? That's on the Mentimeter. You can think about that and enter your answer, and we'll take that up at class. Final word about battery. Let's think about its social context. Let's think about why it is there as a tort action. Now, I should tell you, and you may have thought of this already, that battery is often a crime. So if a person shoots or stabs or strikes another person, that's a crime. And there will be consequences in the criminal system. For that reason, many of the batteries that take place in society never get pursued in civil law, in tort, because the wrongdoer is in prison and perhaps has no money. And from the plaintiff's point of view, justice has already been done. The wrongdoer is serving the penalty. But nonetheless, we do see actions brought in battery often enough. And there are two major social settings in which we see it. One of them is to counter abuses committed by the state, typically police officers. Police officers are having a public duty to engage in conduct that may involve touching people, arresting them, etc. And as we can see from the Collins case, the police officer there overstepped her powers, and battery serves as an incentive against that. So many of the battery actions that we see are brought against police officers. And the second area where we see it is having to do with medical treatment. As you will see in your readings, unconsented to medical treatment is a battery. And sometimes medical treatment is administered without proper consent. When that happens, that might be a battery and action available against the medical practitioners, the medical care providers.